As we all know, the United States Supreme Court has issued a number of really blockbuster decisions in the last several years, and more than a few have had significant implications concerning not just individual rights, which often gets the most headlines, but also about the distribution of power between the branches of our government. There's been a lot of talk, for example, about how the court's decisions have expanded the authority of the president. Trump versus the United States, recognizing very broad presidential immunity, or the adoption of at least a version of the unitary executive. In the next 6 hours, though, we're going to, takes a while, right?
There's a lot to unpack.
We're going to talk about the impact of some of the court's recent decisions on a different branch of government, one that doesn't get the attention that, as a retired judge, I can say it deserves, and that is the judiciary. Recent decisions concerning the authority to issue nationwide injunctions or universal injunctions. There's actually a debate on the court about whether we should call it one or the other. Justiciability doctrines, such as the rule against deciding political questions, the availability of court-created remedies for violations of constitutional rights, the abandonment of deference to agency interpretations of federal statutes, the adoption of the so-called major questions doctrine. These cases all tell us something about what the United States Supreme Court thinks is the nature of the federal judicial power that is recognized in Article 3 and the circumstances under which federal judges should exercise that power, whether they be the federal district courts around the country, the courts of appeals, or the Supreme Court itself. We're fortunate this afternoon to have with us three real experts on this topic. In the interest of maximizing the time, because let me tell you, each one of them has a topic to talk about that could easily consume an hour. So I'm going to forego detailed introductions of them, meaning no disrespect to any of them, my friends and colleagues, but please look at their bios in the materials. We will first hear from Professor Stuart Chinn, who's the Frank Nash Professor of Law here at Oregon, where he teaches con law, legislation, legal and political history. He's going to talk about the implications of the Supreme Court's recent decision in Trump versus Kaza on the lawfulness of federal district court universal injunctions. Professor John Perry is the Edward Brunette Professor at Lewis and Clark Law School, where he teaches con law, federal courts, conflicts of law, among other things. He's going to talk about justiciability, and I know, justiciability at 3 in the afternoon. I'm sorry. But he will talk about justiciability and judicially created remedies. And then Dustin Buehler is special counsel to the Oregon Attorney General Dan Rayfield, where he directs what the Department of Justice calls its federal accountability efforts, by which I understand it refers to the fact that he's in the trenches litigating with the current presidential administration on a variety of matters in federal court. And in his copious spare time, he teaches ad law here at Oregon Law. He's going to talk about some of the recent administrative law developments at the Supreme Court that reflect a shifting away from power of the executive branch and administrative agencies and towards the federal court. So without further ado, Stuart, why don't you tell us about the Trump versus Kaza and its implications?
Happy to. Thank you so much for that introduction, Justice Landau, and also pleased to join these two as well on this panel. I'll try and keep it on the clock to not keep it around 10 minutes or so. Is that? Yeah, okay. So as brief background, what started Trump versus Kaza off were there were 3 overlapping universal preliminary injunctions that were entered by 3 different federal district courts in the legal matters involved here. And the plaintiffs in these cases were seeking to enjoin the implementation and enforcement of Trump's executive order that would limit the scope of birthright citizenship and that would deny birthright citizenship to at least some categories of individuals who were born in the United States. In each case, the district courts involved concluded that the executive order was likely unlawful, and they referenced, of course, the Citizenship Clause of the 14th Amendment and the Nationality Act of 1940, and they entered these universal preliminary injunctions barring various executive officials from applying the policy to anyone in the country. The court got a hold of this and was clear that they were not going to weigh in on the merits, the substantive question of whether this order violated the 14th Amendment or the Nationality Act. Rather, they were interested in this question about remedy and addressing specifically the authority of the federal courts to be able to issue these universal injunctions. So Barrett wrote for the court majority, and she ultimately concluded that if there was a universal injunction authority, it had to be justified as an exercise of equitable federal judicial authority, but she concluded that Congress had granted the federal courts no such power. And there's a great deal of historical background provided to get to this conclusion. She mentions, for example, there was no analogous equitable authority for courts of equity at the time of the founding. There's no support for the universal injunction in practice at the founding era. She notes also that as a matter of the evolution of this practice, that universal injunctions were not a feature of federal court litigation until sometime in the 20th century, and it seems that they remain rare until the turn of the 20th century, after which their use gradually accelerated, and then we see a pretty dramatic escalation of their use in relatively recent years. There is an interesting discussion that gets mentioned, which is sort of relevant for how this debate may continue on about whether the class action, how the class action sort of fits into this sort of array of different remedies. She doesn't get too deep into the idea of the class action as an alternative suit, but she does mention it, and Alito also mentions it as well in concurrence. And then Barrett also gives voice to what has occupied, I think, a fair amount of the public debate about this, which are the policy considerations, pro and con, against these universal injunctions. And basically she says, there are pros and cons, it's hard to adjudicate. She sort of puts them as beside the point and really rests the bulk of her argument on the historical evidence. The other thing in the majority opinion, the sort of last thing that got a great deal of attention was there was a relatively sharp exchange between Barrett and Jackson in their respective opinions here. And so there was a really direct critique of Jackson in the Barrett opinion where the criticism was of Jackson's view suggesting that there should be this unchecked authority of the federal courts to enforce the executive's obligation to follow the law. And Barrett, voicing this point for the majority, says that if you were to take the implications of Jackson's argument seriously, it leads to this concern about the imperial judiciary. You know, Jackson's concerned about the imperial executive. Barrett says, well, what about the imperial judiciary? And I'll just offer this quote from Barrett where she says, quote, but federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. And then the sort of sharpest line towards Jackson in the opinion is this, where she says, quote, Justice Jackson would do well to heed her owed admonition. Everyone from the president on down is bound by law. That goes for judges too. So the ruling here is that the preliminary injunctions are stayed, but only to the extent that those injunctions are broader than necessary to provide the necessary complete relief to the plaintiffs who have standing to sue. Let me just offer a couple of quick words about the other opinions here. Sotomayor offers this point in dissent. She gives voice to an item that had been noticed by commentators prior to this ruling, which was the gamesmanship that's potentially going on by the Trump administration. And the claim is something like this. The executive probably knows that these orders are illegal. So they're seeking to limit the scope of a federal district court remedy so that this illegal order can remain in place for anyone who doesn't bring a lawsuit to challenge it. And so Sotomayor says, you know, given that there's this gamesmanship going on, more or less giving voice to a concern of a lack of good faith here, she sees no reason to sort of cut any slack for the executive in this case. There's a long discussion about the merits of birthright citizenship that also shows up in the Sotomayor opinion. And she also dives a bit into the historical background as well. For what it's worth, in my opinion, I think Barrett is going to have the stronger argument on the historical grounds. But if I had to sort of paraphrase the claim being made, I think, in the Sotomayor opinion, I think it's something like this, that there are maybe kernels of something that look like the universal injunction in the past. And if we sort of take a living constitutionalist approach to that and think about the evolution of these things, that's how you could get to a universal injunction remedy. And then finally, a few quick words about Justice Jackson's dissent. She emphatically presses the view that the judiciary must confront any violation of the law by the executive. her argument is one that is grounded in uncompromising legal principle, which is all well and good, but the downside, at least if you're coming from it from the perspective of Barrett, is that the Jackson opinion is so on top of legal principle that it's almost dismissive of political reality or the prudential elements of what you might think should be important in the exercise of federal judicial power. And so if one goes down the path offered by Jackson of having the court be this vigorous check on the executive, one has to grapple potentially with this question of, well, what's the authority for the courts? You know, the questions that have always oriented federal judicial power, the counter-majoritarian difficulty, these people are not elected, where is their authority for being able to insert themselves in such a profound way in these policy debates? Let me say just a couple of evaluative points, and then I'm happy to dig more into this if it comes up in sort of broader themes with the rest of the panel. One of the things that's sort of interesting about the contrast between the Barrett majority opinion and Jackson is it's indication of a larger conflict that's beginning to show up in other cases, which I'm sure we might talk about in other contexts. There seems to be an interesting split opening up within the federal judiciary between the Supreme Court and lower federal court judges. And you see this where Justice Jackson sort of standing up for these federal district judges that are willing to sort of check the president and calling out her colleagues for failing to do the same. You get also in the same case Kavanaugh's concurrence asserting the authority of the Supreme Court to be the national word on these matters. And then also in some of these cases dealing with cuts to federal funding, there's a concurrence by Justice Gorsuch in one of those cases where he just sort of gives voice to his frustration that federal district judges are not following or heeding the court's rulings enough. So that's an interesting dynamic in its own right, this sort of split between different parts of the federal judiciary. But my main evaluative point that I'll offer just really quickly right now is this. We're accustomed to thinking about these debates around dualities of judicial activism versus modesty. And I don't know how much value that duality has ever had. I mean, it's always been kind of a confusing conflict. But I think it's gotten especially muddled these days. And to offer an illustration, just one illustration of this, you know, Justice Jackson accused the majority of being judicially activist in the Trump versus US case. But here, you know, she's being accused as being the activist for, you know, wanting to stand up to the president and so forth. And so this sort of gives rise to the conventional concern with this duality. It's hard to define what activism is, right? Usually activism is like the negative term applied when the court does something you don't like, right? So how do we tease that out? If I were to offer my own opinion about what the court is doing in this case, but in some other related cases too, I don't know that my concern about specifically the conservative majority is one of activism. I mean, they have been shown quite willing to depart from very established precedents like in Dobbs and in Trump versus US and SFFA and so forth, but that's not what worries me the most. I mean, I think you could make this argument that what seems to be most problematic, at least in this case, is the specter of a conservative majority that is too willing to give the president what the president wants. And so that's not a critique about activism, that's a critique about failure to hold on to established norms, procedures, principles, and so forth. That seems to me the bigger concern. But I'll make one final point here. I think the more important duality to think through as we think about these cases is instead not one of activism versus modesty, but one of realism versus formalism. And just to try to offer this comment relatively quickly, the conventional tools of a judge are kind of more formalist. It's meant to be general principles that apply to universal parties. You know, they're not supposed to issue rulings that are party specific. That's the cornerstone of what we think about as principled adjudication, and there's great value in that. But also we sometimes expect judges to be realists, to sort of take into account the reality of what things are happening in front of them and so forth, to not be blind to those realities. And I think that's the tension that I see in this case. Because on a formalist perspective, the majority opinion, to my mind, has quite a bit to commend it. I don't know that I like the idea of an unelected federal district judge being able to thwart the agenda of a democratically elected president. So stated in the abstract, that makes sense to me. On the other hand, what Jackson is giving voice to is this belief, not shared by everybody in this country, but shared by at least some, and I share at least a little bit of this concern as well, that this president seems to be a little bit different. Right? This is not normal presidential pushing at the outer boundaries of authority. This president is taking things quite a few steps beyond what we've seen before. And that's acknowledging that democratic presidents have pushed the boundaries of presidential power consistently as well. This president has taken those precedents and pushed them forward. So to Jackson's point, to what extent should justices or judges be able to take into account those realist components as well? All right, so I'll leave my comments there. Happy to pick up with them later on, but those are my thoughts on Trump versus Kaza. Thank you. Oh, yes.
So, while John's getting the mic ready, he's going to talk about the topics of justiciability and judicially created remedies. And I made a disparaging remark about justiciability. I should say this is my idea of a good time, talking about justiciability, and I'm really anxious to see what he's. When I was on the Supreme Court, I wrote a 125-page opinion on justiciability. So it's also what?
Was that Cooey?
Yeah.
Yeah, of course it was. I concede my time to you. Right?
No. But it is exceedingly important. In the, talk about realism in the real world. I tell my students, this is something you cannot dismiss as something that's just a bunch of abstract principles. One of the very first things you need to do in any lawsuit, if you're on the plaintiff side or the defendant side, is think about the parties and the extent to which they have an actual concrete stake in the outcome. You have to think about it, and so it's utterly critical to know what the rules are about these topics. John, take it away.
I feel like I've been set up. The rule, I'm about to talk about standing, and he says we're supposed to know what the rules are. So those of you who know anything about standing know that that's an impossible task. One thing I want to say, Stuart just did an amazing job walking us through Trump versus Kaza. I'm not going to walk through the several cases I'm going to be mentioning in quite that amount of detail. I'm going to be sort of pulling out a couple high points from them, because I got a lot to cover, and detailed discussion of a standing case would be, in fact, except for Jack, might be a lot. One way to approach the question of judicial power is to ask for whom that power is exercised. Or more specifically, who gets to ask the federal courts for assistance and who doesn't. And these are topics that are the term would be under the radar for a lot of people, right? I mean, the previous panel, wow, those cases, you've probably heard about them, you read about them in the newspaper, you probably have thoughts about them, but when you hear about a standing case, it's under the radar. It goes less noticed. Only like the four of us up here, or maybe not even all four of us. But they still have a significant impact. That's the point of an under the radar decision, is it can have a significant impact without being noticed. And that, of course, creates opportunities, good and bad. And with the topics I'm talking about, and this is kind of links in some way to Trump versus Kaza, the judicial power angle. What have we learned about the power of the judiciary is no power here, right? We can't do universal injunctions. Often the justiciability narrative seems to be one of withdrawal or of restraint, depending upon one's perspective. Although now I'm going to talk about two standing cases in which the court said there is standing. So standing is really interesting because it's long been seen as a flexible gatekeeping doctrine, a passive virtue, in Alexander Bickle's words, that allows the court to manage what gets to federal court. If you don't have standing, you don't have a case. And if you remember from whenever you learned about standing, Article 3 requires plaintiffs to have three things. You have to have injury, and that injury has to be caused by the defendant, fairly traceable is the term they use, and then it has to be redressable by the court. So those are the three things. Not an issue for your typical private law case, right? If you run into me with your car, I'm injured, I can trace it to you, and I can get a remedy money against you. So it's in public law cases where we see the weight of standing doctrine. The Supreme Court had two pretty interesting interesting standing cases on its docket last term, both of which involved the issue of redressability, the third prong of the standing test, and in both of which the court found that there was standing, raising the question whether there's something going on with redressability. Diamond Alternative Energy versus EPA, 7-2 decision. Fuel producers have standing to challenge the EPA rule approving California fleet-wide emission standards for miles per gallon. I probably lost, well, I don't know, we're Oregon, we're very environmental. And because if those standards go into effect, the fuel producers have standing because if those standards are in effect, they will lose money. right? I'm now going to have an electric vehicle, or, fleet standards are going to be 30, 35 miles per gallon. People will be buying those cars. They will use less gas, and I will therefore have less revenue as a fuel producer. And there's a real logic to that, right? And that certainly makes sense. But they're not actually regulated by this EPA action, right? The EPA is approving California's regulation of car manufacturers, right? And they're not regulating fuel producers in any way, shape, or form directly. They're also not regulating consumers directly, right? They're both the consumers who are buying gas and the fuel producers are third parties, right? And so the fuel producers' claim requires this chain of not the regulated entity, but then this extra step of the consumer coming in and taking actions in the marketplace, and then causing injury to the fuel producers. And the Supreme Court has been historically pretty skeptical of claims that insert another party in between the defendant and the plaintiff. And it's pretty skeptical, I think, is a kind word. They basically said no, because it's too speculative. Here, Justice Kavanaugh, writing for the court, said, well, maybe so, but we're going to apply common sense economic principles. And that's the quote. That's essentially the work that is happening in the case, is the idea of common sense economic principles. I don't want to be snarky about that, because I do think his logic makes sense, right? Again, it's pretty clear that if we raise fleet-wide, miles per gallon and emission standards and things like that, that there's going to be less gasoline purchased. And so if I'm a fuel company, I'm going to make less money. That's an injury. That's a wallet harm, a pocketbook harm. So that makes a lot of sense. It's logical, it's realistic. It leaves out the sort of long-term planning of the audit. There's a lot of other pieces that aren't there, but it does make some sense. Justice Jackson, though, has an interesting dissent here. She says, all well and good, but this is a change from these other third-party cases. And we're not applying the standing doctrine even-handedly. So this kind of fits in with Justice Jackson's dissents of the last term, where this kind of realism and willingness, almost kind of staking out a role that a young Antonin Scalia once staked out in a very different court. Well, I don't know if he was ever young, but so she says, some people are old souls from the beginning, right? Standing, she says, is a constitutional doctrine meant to promote judicial restraint. When courts adjust standing requirements to let certain litigants challenge the actions of the political branches but preclude suits by others with similar injuries, standing doctrine cannot perform its constraining function. And then she goes on, not just to accuse them of inconsistency, which I think is not totally accurate, but fair enough. Then she says, over time, such selectivity begets judicial overreach and erodes public trust in the impartiality of judicial decision-making. So, going back to that earlier dichotomy, you're not being restrained, you're being activist. And when you get out there and get activist, and people see you doing it this way for one group and that way for another group, everyone's going to think we're biased. So not really, that's pretty apparent. She's not even like burying it in legalese. And so she says the court seems inconsistent in its willingness to premise redressability on common sense inferences about third-party behavior. That inconsistency, which we reinforce with today's holding, tends to redound to the benefit of particular litigants. The Constitution does not distinguish between plaintiffs whose claims are backed by the Chamber of Commerce and those who seek to vindicate their rights to fair housing, desegregated schools, or privacy, all previous cases about third parties. So I guess my takeaway from the case is I'm actually fine with the standing ruling in this case. It does make sense to me that fuel producers have been injured. But I think Justice Jackson's right. Standing has always been this kind of strange doctrine where the results are inconsistent, but there seems to be, at least on the surface, a stark divide between these two sets of cases, where the easy to show wallet injury of a big company versus the somewhat harder to show individual harm. And the way that we call it common sense economic principles creates a kind of disparity in treatment. You could say that's just dollars and cents versus vibes or something, but I think it's more than that, and there's something more there. Second standing case, 6 days later, is Gutierrez versus Sainz, 5-1-3. So that Kagan, Kavanaugh, and Roberts are the only ones who are in the majority in both of these cases. The one is Justice Barrett, who agrees with the result but does not agree with the court's reasoning all the way through. This is a prisoner on death row in Texas who wants to have DNA testing of some of the things found at the scene of the crime, says it's going to show I did not hold the weapon, I didn't commit the crime. And the prosecutors, we're not going to let you get your DNA testing. So files suit, says, I want access to this evidence to have it tested for DNA. And the prosecutor says, even if you win, we'll find another reason to say no to you. And so the Fifth Circuit says, well, in that case, if the prosecutor is never going to let you have this, then we can't redress your grievance, because even if we rule for you here, they'll come back around and take it away from you on remand, which is, a bit of an odd thing to give weight to. The court said that's wrong. Right? Removing the barriers that have been erected so far is enough redress. That's what the person sued for, was removal of the barriers that have been articulated. The reasons why they would not allow DNA testing. If they come up with a different reason on remand, that doesn't mean we didn't give you the redress you were seeking. So there's a kind of formalism in that analysis, right? That you asked for this, we gave you this. That doesn't mean you get everything that you might actually want. And here, this also seems correct to me, this case. I like cases that are formally correct. It makes it easier. But it's an interesting connection to Trump versus Kaza, because one of the things that you actually didn't talk as much about was Barrett talks about the idea of complete relief in Trump versus Kaza, and what is complete relief, and how much relief can we give to a plaintiff. And here, the plaintiff is actually getting the relief they asked for. It may not be complete in some larger metaphysical sense of making the whole world better. But of course, as lawyers, right, we're always dealing, I don't know when we ever deal in complete relief. Most clients are out something no matter what you get for them, right, at the end of the day. So we're always dealing with incomplete relief. So I found both cases to be fine. Not that my judgment is all that important, but we do get some real relaxing of the redressability component here. It's not clear if these cases are fitting together in some kind of larger re-theorizing of redressability. I would say no. I think they're both 2 points, and it's really hard to graph justiciability. Now for the more interesting part of standing. I will spend most of my time on standing. I can leave those. The shadow docket. Dun, 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 dun. Standing is part of the shadow docket. So in Noam versus Vasquez Perdomo, the recent case about LA and ICE activities there, there was no explanation in the actual stay of the Ninth Circuit order, but Justice Kavanaugh wrote a short statement analogizing this case to a famous case called City of Los Angeles versus Lyons, where the court said you have to show standing for each form of relief you seek. So if you're seeking an injunction, for example, against LA's chokehold policy, you have to show that you have an imminent injury in order to have standing to get that injunction. And in Lyons, they say, are you telling us that you're going to go out there and engage in illegal activities such that the police are going to stop you and put you in another chokehold? We don't find that credible. And Kavanaugh says, well, this is kind of like that. And on the surface, there's something to be said for that, but a lot of commentators have pointed out that we're not talking about people who have to make that kind of allegation, because the plaintiffs in Noam had a specific risk of being stopped by ICE because of their appearance, the language they were speaking, and where they were, at places where they were seeking work. So it seems to me it is actually distinguishable. But if Justice Kavanaugh's invocation of the Lyons case does reflect the majority view that this was a standing problem, then we should expect to see some kind of articulation of a stronger doctrine against being able to seek injunctions. I'm not quite sure what that would rest on, but there's something there. And sometimes I don't always give a lot of weight to some of the Kavanaugh stuff, so maybe he's just throwing that out there. There were other issues in that case with the scope of the injunction, what it meant. It was maybe not the best crafted injunction, so there were other things that they could have grappled with. Office of Personnel Management versus American Federation of Government Employees, reinstatement of 16,000 probationary employees. The case is brought, though, by the unions, not by the employees. The district court said they had standing based on the diversion of resources theory of standing, which is a bit of a niche standing theory that has always been a bit precarious. And the court stated without elaboration that the organizational plaintiffs are presently insufficient, their allegations are presently insufficient to support their standing. And because it was a shadow docket ruling, that's all we get. We get a conclusory statement. So one thing that happens on the shadow docket is, and this comes back to this Supreme Court, federal court, lower federal court relationship is some district courts, in the view of the Supreme Court, have gotten a little too far out in front, being too quick to take the cases and reach the merits decisions. They haven't looked as closely at these really important justiciability things. They didn't have Judge and Professor Landau teaching them these things. So they're being told to go back to first principles. Maybe. I mean, maybe that's true, that there's a lot of standing problems here, and some of these, shadow docket orders are simply correcting these things and looking for the right plaintiffs. But of course, it could also be, I don't know whether we would still call it a passive virtue or not, but it could still be situations in which the court is using standing to avoid confrontation with the executive branch, or to put it off as long as possible, or to pick its battles of when it will or when it will not, which is a classic use of standing. Have I used up all my time? I might have. That's good. I'm going to say one thing about rights of action, which is the keynote speech talked about the case coming out of the Eighth Circuit on Section 2 of the Voting Rights Act. That is a rights of action case. And there's a really interesting question there about whether the court will, in fact, say that the use of the word rights in the Voting Rights Act is enough to trigger a private right of action, or rather trigger the Section 1983 right of action, or whether there's something else there. And that gets to this formalism. The only thing I will say is this gets deep into the formalism, realism stuff that Stuart was talking about.
There's a terrifically interesting, deep topic about the scope of federal judicial power generally.
Yeah.
We have Bivens actions, for example, where the Supreme Court created, recognized, whatever verb you want to use, a private right of action for damages for violations of federal constitutional rights, in that case, Fourth Amendment rights. Where did the court get the authority to do that? And there have been some recent cases in which the court has been shrinking Bivens as we go. But
that's a kind way to describe those cases.
Yeah.
Justice Kavanaugh, though, did refer to the ability to seek remedies in the Nome case, and everyone said, well, what remedies?
Right, right. And then when statutes confer on some people, like the Attorney General, the authority to enforce the Voting Rights Act, does that implicitly create a right of private persons to also bring Section 2 actions? Stay tuned.
Yeah, or
right?
does it show that Congress didn't want them to because the AG can do it?
And I mean, our topic is federal judicial power, and it's really interesting to me as a state judge because there's an important distinction here. State courts have the judicial power generally, and so there's a lot of power that comes with that. I mean, state courts have been exercising judicial power in the area of tort and contract law, for example, for the last 1,000 years. Right. And we don't need statutes. We've been creating, modifying, eliminating torts for generations. Federal courts, it's a real tricky issue about the scope of federal court authority to create, alter, modify remedies. But let's move along to the equally interesting and important area of administrative law. And I think as we've all, anybody who hasn't been spending time in Iceland lately knows that the Supreme Court has been issuing a number of decisions, Loper-Bright versus Raimondo, which it overruled Chevron and the whole idea of Chevron deference, Jarkissi, in which it invoked the Seventh Amendment, saying you can no longer have non-jury quasi-judicial administrative decisions that result in the imposition of civil penalties, the major questions doctrine. Those are the kinds of things that Dustin's going to talk about in the next 10 minutes.
Yeah, it's such a pleasure to be here, and really a pleasure, John and Stuart, to listen to your comments. Standing and Trump v. Kaza, I lived that in the opening days of the Trump administration because the states were plaintiffs. And we were thinking very carefully about standing and could we bring these claims. And then, lived through Kaza when the Supreme Court in 2 paragraphs basically punted on whether the states can get universal relief. So stay tuned on that. That's a question that has not yet been answered. It's just a joy to be here on the university campus on a Friday in September when it's nice weather. You walk around campus and you think to yourself, hey, even though I went to law school at the University of Washington, this is kind of the way it should be. It's just beautiful here on the University of Oregon campus. And I'm really honored to be here to talk about something that intersects in my life in 2 different ways. So As Justice Landau mentioned, I work for Attorney General Rayfield, and unfortunately or fortunately, 150% of my job is coordinating our effort that now spans in 8 months of this administration, presidential administration, across 37 different multi-state lawsuits that Oregon is a party to, has filed or joined. And to date, for those that are counting those lawsuits through preliminary injunctions or the federal government just backing down, have saved Oregon somewhere in the neighborhood of $4.4 billion of essential funding. So these are real things. They affect real life, whether it's standing or other things. We think about these things really carefully because it affects this state when we bring these lawsuits. The other thing I'll mention is, look, I have the joy or the terror or something of intersecting with all of what's happening in this country as an adjunct who teaches administrative law in the U of O's Portland program. So it was kind of unreal, frankly, the first, the whole thing, the whole course, in the spring of this year, because I would just show up and my students would just look at me. I see Adele had the same experience here. And they're just like, can you do that? And I would say, I don't know. I don't know. Nobody's ever tried this before. And it's like, I guess we'll find out. I have no idea whether he can strangle this agency in the bathtub or if he can not spend federal money, or if I just don't know. It seems kind of like he shouldn't be able to do that, but we're going to find out. So today what I want to do just briefly in my remaining time is focus on two of these administrative law doctrines or things that have been getting a lot of play, both with the geeks here, but also just in the media. We've heard a lot about these things, and that's the demise of Chevron deference, and then also the major questions doctrine. Justice Landau, you referred to that as the so-called major questions doctrine. I think we're on the cusp of it being more than just so-called, for better or worse. And I just want to talk about those two things for a couple minutes and then do a little bit of a prelude of what's to come this fall in the Supreme Court, because when it comes to administrative law and some of the things we think about, the collection of tariffs cases that are now on the Supreme Court's docket, one of which is a multi-state lawsuit where Oregon is leading. It's Oregon v. Trump. We're leading a 12-state coalition now in the Supreme Court challenging the president's tariffs under the Emergency Economic Powers Act. Because I think that case actually shows a lot of these issues playing out, and actually will be somewhat of a precipice to see, well, which way is the court going to go on this? Are these neutral principles that really do apply across the board, or is Justice Jackson right that this is like some form of Calvin ball, like we saw in Calvin and Hobbes, where there are no rules, and as she adds, the administration always wins? I mean, I think that the jury's out, and that particular collection of cases is going to illustrate this kind of turn point in a pretty dramatic way this fall. So just really quickly for those that have not been living in Iceland, as Justice Landau says, we all saw the not surprising demise, given the court's current composition, of Chevron deference. When we were in law school, I was in law school, I learned that there's this really important doctrine that came out of Chevron versus NRDC in 1984, which, even though I used to cover it for 2-3 weeks, can really be, truth be told, summarized as follows. When there is a statutory ambiguity, when the statutes are not clear as to whether an agency can do a thing or not do a thing in statutes that it's been tasked to administer and implement, the agency, traditionally, since Chevron, has received deference from federal courts to render a plausible interpretation of the statute and its power under the statute. And for many years, I would teach this and say, hey, doesn't that seem kind of bizarre, everybody? Because we're taught that when a reviewing court reviews a matter of law, a question of law from a district court, you're supposed to review that de novo, which basically means there's no deference when you interpret statutes. And yet, for 40 years, we were in a world where if you were an administrative agency and you were interpreting an ambiguous statute and exercising power according to that interpretation, you were given deference by courts for that interpretation as long as it was a permissible or plausible interpretation, even if it wasn't the best interpretation. And then just 2 years ago in Loper-Bright versus Raimondo, the court overruled Chevron. and did so in a way where the court was relying both on constitutional principles and then also the Administrative Procedure Act. So the court said that a notion of deferring to an executive branch agency on a question of law is just diametrically opposed to something that goes back to Marbury versus Madison, where the court in that case said that it's emphatically the province and duty of the judicial department to say what the law is. That's the role of courts. And there'd been that tension since Chevron, right? Courts had been willing to defer to agencies because they were the experts. And then in Loper-Bright, the court says, no, that is just not how this works. We are the branch that interprets statutes and ambiguities in statutes. And the court also said that under the Administrative Procedure Act, Section 706 of the Administrative Procedure Act also seems to suggest that questions of law should be reviewed in a non-deferential way. That's at least how the court read the statute. Now, you can interpret Loper-Bright in one of two ways. I promised myself I would come here and not be cynical. So that is what I will attempt to do. I'll give you the non-cynical version of Loper-Bright, and then I'll give you the dark soul cynical version that I subscribe to, and perhaps some of you do too. So, not cynically, and with neutral principles in mind, you could say that Loper-Bright is a recognition that it's the role of Congress to legislate, and it's the role under Article 3 of courts to interpret those statutes, and that really executive branch agencies, which weren't even a glimmer in the eye of the founders when they crafted all of this, have no role to play there, and that the court was merely defending the constitutional prerogatives of not one but two branches of government. Sounds good, right? Now, the cynical side of that, which I happen to subscribe to, is, for whatever it's worth, right or wrong, is that the court, by taking back that power of interpreting a whole host of statutes and taking that away from agencies, that is a very significant step in what I think is a clear trajectory where this Supreme Court is very hostile to the administrative state and is kind of engaging in an exercise of drowning that administrative state in the bathtub. Some argue slowly, some argue quickly. So that's kind of the lay of the land on that. And then when you overlay the major questions doctrine, the interesting thing there is that, you know, you could argue there's some sort of precedence for this or there's not, or they invented it out of whole cloth. But the whole premise of that doctrine is that when there are agency actions, executive branch actions of vast economic or political significance, Congress needs to speak clearly in the statute and authorize that clearly. And so if, for example, you're President Biden and you want to implement a nationwide eviction moratorium during COVID-19, you better point to something that's pretty clear on that in the statutes. And what the court said in that case some years ago was Biden did not have that clear authority. What's going to be interesting, I think, coming up this fall is that the tariffs cases under IEPA, I've never seen a better case for major question doctrine. Nobody can argue that these tariffs, that a tariff authority where the president thinks that in the invocation of an emergency he can place tariffs of any amount at any time on any country and change them however he wants is anything but something of vast political and economic significance. And oh, by the way, the power to impose tariffs is an Article I power. It was explicitly given to Congress. And so I think we're going to reach a moment here where we're going to find out, look, is the major questions doctrine a neutral principle here that applies to Republicans and Democrats alike? Or are there creative ways, perhaps through legal sophistry, that the court is going to use the rules in a different way? And I think that that's what's coming up in the fall, and we're going to see how that plays out. I'm cognizant of time, and so I'm going to just end there with that cliffhanger for you all to think about.
What a terrific observation. I mean, one of the things that I've noticed in the Supreme Court's cases in this area is that it seems to be on two different tracks, and one track doesn't seem to know about the other one. And that is, on the one track, the court's cases are constraining the authority of administrative agencies. On the other track, it's expanding the authority of the president to whom all these agencies supposedly report. And your tariffs case presents a wonderful opportunity for us to understand how those perhaps intersect. There are so many questions I want to ask. Starting with Stuart, Trump versus Kaza, you mentioned that the majority took a historical approach which it clearly did, which raised a couple of questions in my mind, and all three of you can jump in here. But the first is that the court said that the absence of any examples of universal injunctions in English common law and early American law is dispositive. And the judge in me wonders at the logic of the court's decision. Is it perhaps confusing an absence of evidence as if that were evidence of absence? That's my first kind of sub-question. My second is that it presents a kind of level of generality problem when you start going down these historical roads. I think it was Justice Sotomayor's opinion cited the Bill of Peace as an example historically that's very close, or at least arguably close, to the kind of universal injunctions that we're talking about here. And the majority said, no, not close enough. And that reminded me of the gun case in Bruin versus New York Pistol and Rifle Association, when the question is whether there's a historical predicate for regulation of your right to bear arms. And the state of New York came up with one example after another, after another, after another, dating back to the 13th century. And the Supreme Court said, no, not close enough. That one, no, that was on a Tuesday. No, that was not close enough. And I'm wondering if we're confronting the same kind of dynamic in Trump versus Kaza. Take it away.
Wow, all right. Great question. No, this exact question about the level of generality for historical evidence is it's in my mind, the core question, right? And I think Bruin's an excellent example of that problem. And I think it should suggest the pitfalls of looking to history as the sort of basis for some, I mean, don't get me wrong, I make this argument in my class as well. I do think looking to historical traditions and so forth is an important part of constitutional interpretation, but I don't think it can bear the weight that at least some members of the court would want to utilize it for the exact reasons we're talking about. And also, it's not helped as well that, think about Bruin as a good example. The use of history in the SFFA case as well by Justice Thomas didn't get high marks from historians who will, talk at length about what the original intent may have been with respect to race-conscious measures under the Reconstruction Amendments. And so those are pitfalls of historical inquiry. This is a little bit of a tangent, but related to this. If I was thinking about adjudicating the merits of the universal injunction, I think the policy things that Barrett was inclined to put to the side are more what I would sort of find compelling and interesting. And sort of related to some of the other things that sort of came up in other comments by those on the panel, I think we are, and this is a dynamic that is decades running, but we're maybe getting to a more intense part of it. We're entering a form of governance that's by executive order and judicial action. I mean, this is what it looks like when Congress can't legislate, right? And that's why I strongly suspect the reason why we see this uptick of the universal injunction is precisely because of a dynamic of a paralysis in the legislative process. And so we're grappling with all the dysfunctions that sort of flow out of that problem.
Dustin, you mentioned in Loper versus Raimondo that the court rested largely on Section 706 of the Administrative Procedures Act, but there are also some constitutional separation of powers underpinnings.
Yeah.
My question is, if the court's really serious about the separation of powers constitutional underpinnings, how is it that the court believes that Section 706 itself is constitutional?
Right. I mean, it's a really good question. I found that part of the opinion odd. No, I'm being, and funny. No, I'm being really serious about that. Look, if I were to, you heard me, if I were to defend the thing that they did, I think it's constitutional. Like, come on. Like if you're going to put that stake in the ground and you're going to say that agencies have no business interpreting law, who cares what the Administrative Procedures Act says? And I found it curious. I don't know what was going on in the court or the internal dynamics. Chief Justice Roberts, writing for the court, pivots very quickly off of the constitutional rationale, almost like it's not really the basis of the decision. It's just kind of some preambulatory throat clearing, and then grounds it really solidly in the APA. And look, court can do what it wants, still means Chevron's dead. But to your point, it just seems a little bit logically suspect to me that the court would say the thing that really is going on constitutionally and then prop up the statute that makes it okay.
John, you mentioned, if I remember correctly, it's the Diamond Alternative case. Yeah, that's the case where we're talking about the fuel companies who are saying if the California rule is upheld, then people are going to buy fewer gas guzzlers and we're going to end up making less money. And when I read that opinion, I found myself thinking about U.S. versus Texas. And in U.S. versus Texas, we're talking about the Biden administration saying we're not going to enforce certain immigration laws. And so Texas sues and says, but wait a minute, to the extent that the federal government is not enforcing the immigration laws, that creates a financial burden on the states because we're going to have to devote more law enforcement resources. And the court says, that's not an injury. Am I missing something? Or is this just another one of those oddball points in the graph about what makes standing so interesting?
Okay, so the really easy answer is, well, that's state standing.
Yeah.
It's totally different.
Yeah.
No, but I mean, in the Texas
It's totally
case-
different.
Yeah. And I will just kick it over to Dustin. But,
The answer is we have standing if we're states.
but in the U.S. versus Texas case too, they were backing away from the idea of special solicitude towards the states, which is one of the, something that, again.
That kind of
Dustin's gonna be
Massachusetts versus EPA stuff. Yeah.
Yeah,
They
which
are
has
backing away from
always been a tricky case. You know, is it going to be, I mean, and then another mildly flip answer would be, well, maybe it really just comes down to actual dollars in a more direct way. I'm not making money in the marketplace, which then just kind of bumps up Justice Jackson's, oh, so if you're in the Chamber of Commerce, you get standing, but if you're a state, you don't, and if you're an individual and you're trying to get other, government benefits, you don't. And so some others are kind of a public-private idea there, like these public things versus these private things. I would say standing, every few years someone writes a brilliant law review article with a normative theory of standing, and they are so good, these articles, they're so good. They bear almost no relationship to the real world of Supreme Court standing doctrine, right? And it's not the professor's fault. I mean, there's what do you do with all these things, right? You have to throw some things out and put some other things in. We need a better normative account of standing, which, and I don't have it to answer that question. I would say we need also, in light of our panel, a better normative account of what the judiciary is for. But also, Congress came up quickly and then left again. We also need Congress, right? I mean, we need an actual functioning Congress. And so when Congress drops out, we are actually in a kind of crisis moment for the other two branches, no matter who is in charge, I think. So that's-
And in the meantime, as a judge, I just find it disheartening that you can peruse the cases, and in one case, you'll find Justice Alito complaining that the court apparently finds standing when it wants to get to the merits. And in another case, you'll find Justice Kagan saying, well, apparently the court just finds standing when it wants to get to the merits.
And that's Alito dissenting from a Kagan opinion, and Kagan dissenting from an Alito opinion, right?
Yep.
They agree with each other.
Yeah. Yeah, go
Right,
figure.
and to be fair to the current court, anybody who's been teaching like the sort of con law structure stuff or federal courts for longer than 5 or 10 years has been saying the same observation in class every semester to students who are struggling to understand what this
Well,
is. Right?
speaking of federal courts and things procedural, Stuart or any of you, one of the things that we've seen occur after Trump versus Kaza is a few federal district courts simply granting provisional class certification and then going ahead and entering the injunction as to everyone. I guess the question is, can federal courts do that? Is that just a clever end run around Trump versus Kaza?
I'm going to defer to others who know more about federal courts than I do. I mean, I think it's illustrative of this interesting conflict that seems like it's going to continue to widen, right? But yeah, I'll defer to these two on that.
Well, and I mean, you probably have a better answer doctrinally, John, but I would say as a crass person in trenches somewhere, look, when CASA was coming up and when it was decided, I think before it was decided, we were all like, who cares? Because honestly, it's just going to be a bunch of class actions and the states are going to keep doing what we're doing. So like, That is literally what's happening. And so I understand the Supreme Court needed to say a thing about universal injunctions. That's been a long time coming because suing the president has been a real popular game for a long time. And it's getting more popular over time. So they had to do something about that. But I'm just not sure that decision practically is changing much on the ground yet. Although, what do you two think about that?
So in the class action point, there, I mean, you should have my colleague Bob Clown up here, but I would say there's a couple different takes on it. There is this sort of, kind of like your two takes on local, right? One is like, well, you know, class actions there, that provides a route. Then there's this sort of dark night of the soul take, which is that's just the other shoe waiting to drop. One thing I will say about provisional class certification, though, is that you've only certified the class provisionally, yet you've entered relief.
Right.
And that does create a problem. I mean, if you were to go through the class certification process, allow the government to raise its ever-growing laundry list of objections to class certification, some of which might have some merit to them, then when you certify, you have a more robust decision. So I do think that some of the district judges are putting another target on their backs, and I shouldn't say that in the light, but they're putting a judicial target on. They like, look, we skipped the process and went ahead to this provisional certification. I don't see that in Rule 23.
Yeah, and maybe they just tighten up the class action mechanism over time. Maybe that's just inevitable.
I just think they're asking for a reversal on that.
Yeah. I'll throw in a quick one too. In our pre-panel phone call, we briefly talked about these cut to federal funding cases, which Dustin knows more about than I do. But I think that's another context too, where notwithstanding a pretty sympathetic to the president ruling recently, there seem to be suggestions that there are other routes to pursue in terms of getting this funding restored, and so it could be a similar dynamic we see there as well. But more than I do.
Well, and I'll just chime in really. Thank you. That is something I think a lot about, and I think a lot of us think about. So what Stuart, I think, is referencing is that in two cases, Department of Education versus California, and then more recently NIH, the NIH cases, the Supreme Court is pushing back on the ability of states and others to challenge grant terminations. And what the Supreme Court is saying is if you want to challenge a grant termination of a federal grant, which, that's kind of in vogue right now because they're terminating a lot of grants that are really important, you got to actually go to the Court of Federal Claims, which the Supreme Court says has exclusive jurisdiction over that. Now, here's the problem with that. The Court of Federal Claims cannot grant preliminary relief. So what is the value of going to a court if you can't get an immediate order that says knock it off? And so what you see is a lot of litigants and district courts resisting that, even though they've now been told twice, you got to start sending them there. And here's why they can get away with that. It's not just insubordination, as Justice Gorsuch says it is. It's because this is all shadow docket stuff. Literally, these are 8-sentence orders from the Supreme Court with voluminous opinions that follow them, none of which commanded a majority. And any district court judge or litigant has more questions than answers after that. And so until they clean it up with a better opinion, I think you're going to still see confusion.
Well, you mentioned the shadow docket. Just a quick question. I understand correctly these emergency docket, shadow docket, whatever you want to call them, orders, they have no precedential value, except when they do. Right?
Didn't they recently
and
say they did?
They recently said they did.
Yeah, they do now, Jack.
Yeah. It's Purcell for years, right? It's a shadow docket order, and so you've got a 3-line unexplained opinion, and then Justice Gorsuch calls out the federal district courts for their inability to define what it was that they actually said. I mean,
the Oracle of Delphi has spoken.
Yeah.
What is it? Yeah. I mean, and in the most recent one, we ended up, Gorsuch is actually speaking, he's accusing the district courts of ignoring the clear priority, but he's in dissent.
Yeah. Here's the other.
So how can he even be right?
And here's the other thing. So for anybody who wants to look it up on Westlaw, there is a merits docket, long-standing, published opinion from the United States Supreme Court that we've had for decades called Bowen v. Massachusetts. And Bowen v. Massachusetts says if you have these types of grant termination claims, you can go to district court. So we keep getting these blippy shadow docket admonishments accompanied by raving Gorsuch dissents, and yet the Supreme Court has not touched Bowen. What are we supposed to do with that?
We're supposed to draw the same conclusion that we're going to draw about Humphrey's executor.
Maybe that's true. There's storm clouds coming.
Yeah.
So final Well, that's it.
I think that is a beautiful place to end. I thank you so much.